My name's Dorothy Larson, Larson and Associates CPAs. So excited to see you all here this morning for a great program. And I'd like to bring up Linka Kaloma, who has Club Detox, and she has been serving samples of detox beverages in the back, and she'd like to tell you just a minute about what her company does.
Thank you and good morning. Club Detox is actually all about health, energy, and vitality. So if you are ever interested in feeling better, more energetic, probably losing some weight, that's what we do about. We offer detox programs which are basically designed to balance the body, get the inflammation out of the system. Because inflammation is unfortunately linked to many chronic diseases ranging from diabetes, heart disease, cancer, and everything in between. So we have fantastic detox programs which basically help the body to remove the toxic accumulation, get the inflammation out of the system. You will lose weight, you will gain new energy, you will feel fantastic. We have amazing results. We are endorsed by many top doctors, going all the way to Sinai in Los Angeles, a lot of naturopathic doctors. And Club Detox basically started with me being very sick. I was diagnosed with many chronic diseases for 30 years, which led into cancer, and that was my awakening point. And basically the detox protocol healed my body. I lost 25 pounds, and that's how the company got started, when other people wanted to experience the same phenomena without being drugged and organs cut out and being poisoned. So that's what we specialize in. We are located in Bayside, 1040 Bayside Drive here in Newport Beach. We also have another location in Laguna Niguel, and we hope that we will see you there. Thank you so much.
Thank you. And the good news is you can sample her products in the back, and they taste good. And she sold me on the weight loss thing. So I would like to bring up Steve Rosansky, the president of the Chamber of Commerce, for a couple of introductions.
Good morning, everybody, and welcome to Wake Up Newport. So we have a couple of quick introductions here. We're actually thick this morning with mayors and ex-mayors. So I'll first introduce our current mayor. Where was he? Ed Selich, over here on the left. We also have with us this morning former Mayor Rush Hill, former Mayor Dennis O'Neill, former Mayor Todd Ridgway, Planning Commissioner Corey Kramer. We have two Harbor Commissioners, Joe Stapleton and Paul Blank. My sister Robin Grant's here this morning. She's head of the Board of Library Trustees. Thanks to the library for letting us use this great room every morning, first Thursday of the month. Pierce Swan with the Irvine Ranch Water District. He's the director there. And I'll finish up with our newly declared Citizen of the Year for 2015, Paul Watkins. If I missed you, I'm sorry. I did this rushed at the end. Thank you all for coming. I'll have a few closing remarks. Oh, Bob Shelton, that's right. I'm sorry. Where's Bob? I know I missed somebody. There's Bob. Thank you all.
And I commented earlier, I'm glad all of our former mayors are so interested in constitutional law. I think that's a good thing. And with that, I do want to bring up our speaker. We are really honored this morning to have Erwin Chemerinsky. He's the founding dean. I'm sure you all know all of this, but he's the founding dean at the U.C.I. Law School and highly esteemed, distinguished professor of law. He's taught at Duke for quite a long time at USC, where Robin Grant was a student of his, at UCLA and DePaul. He has several areas of expertise in the law, of course, but constitutional law is chief among them. And his latest book, which I think sounds fascinating, is The Case Against the Supreme Court. A lot of us think maybe someday I'll write a book. He's written 8 and over 200 articles on the law. Just a very, very distinguished professor from Harvard Law originally, and I'd like to bring up Erwin Chemerinsky.
Thank you so much for the kind introduction and the warm welcome. Thank you for coming so early in the morning. By any standard and by all measures, it was a historic term in the United States Supreme Court. The Supreme Court decided 66 cases after briefing and oral argument. It's almost exactly the same as the 68 cases decided the year before, the 73 cases decided the year before that, 65 cases decided the year before that, which is the smallest number decided in any year in my lifetime. I mention this because through much of the 20th century, the Supreme Court was deciding over 200 cases a year. As recently as the 1980s, the court was averaging over 160 decisions a year. To go from 160 cases a year to this term 66 is truly dramatic. For the first time ever, the justice, most often the majority, was Justice Stephen Breyer. He was the majority in 92% of all of the decisions. For the first time ever, the justice, most often the majority, in the 5-4 decisions was Justice Stephen Breyer. He was the majority in 3/4 of the 5-4 decisions. I think this reflects something very important about the Supreme Court's term. The 4 liberal justices, Ginsburg, Breyer, Sotomayor, and Kagan, were in the majority in almost all of the major high-profile cases of the term. In fact, you might have seen an article in the New York Times saying that this was the most liberal term of the Supreme Court since the end of the Warren Court in 1969. It's worth taking a moment to think about why and what's it likely to mean for the future. I think in part the explanation comes from the voting pattern of Justice Anthony Kennedy. There were 14 5-4 decisions that were split along traditional ideological lines. That's on the one side, you had Chief Justice Roberts and Justice Scalia, Thomas, and Alito, and on the other, Justice Ginsburg, Breyer, Sotomayor, and Kagan. Justice Kennedy was the liberals in 9, and with the conservatives in only 5. If you would look at the prior 9 terms of the Roberts Court, and this was the 10th year of the Roberts Court, Justice Kennedy had been with the conservatives 70% of the time, and with the liberals only 30% of the time, in the ideologically divided 5-4 rulings. But that doesn't tell the whole story. Another part of the explanation was the cohesiveness of the liberal bloc, Ginsburg, Breyer, Sotomayor, and Kagan. There were 19 5-4 decisions overall, and those 4 justices voted together in 16 of the 19. So even in cases where Justice Kennedy didn't join them, they could be the majority by getting Chief Justice Roberts, Justice Scalia, or Justice Thomas. If you look at the 6-3 cases, this even becomes more apparent. Now, I saw some newspaper articles suggesting that this indicates that the Roberts Court is moving to the left and becoming more liberal. I would caution against drawing such a conclusion. I'd caution against drawing any generalizations from 1 year of the Supreme Court. A year ago, the dominant story about the Supreme Court was the unanimity. A year ago, 66% of all the cases were decided unanimously. This year, only 34% of the cases were decided unanimously. For next year, the court already has on its docket cases about affirmative action, the First Amendment rights of non-union members, and voting districting. It's very likely to have 1 or more abortion cases. These are all areas where Justice Kennedy historically votes with the conservatives much more than the liberals. So if for liberals this term was the return of the Jedi, for conservatives next term very well could be the Empire Strikes Back. Now, I tend to follow instructions. I try hard. And so I was given, as you may have seen, an announcement for today's program. And it says I'm going to talk about 5 areas. It says same-sex marriage, Obamacare healthcare subsidies, voting redistricting, employment discrimination, and death penalty lethal injections. So, since you might have come to hear about 1 or more of those areas, I'll take about 15 minutes and talk about those 5 areas, and then I'll use the last 15 minutes for questions. The first area that's listed here is same-sex marriage. And the case is Oberfeld versus Hodges, decided on Friday, June 26th. It involves laws in Kentucky, Michigan, Ohio, and Tennessee that prohibited same-sex marriage. I think to the surprise of no one, the Supreme Court ruled 5-4 that such laws are unconstitutional. Justice Kennedy wrote for the court, joined by Justices Ginsburg, Breyer, Sotomayor, and Kagan. Chief Justice Roberts, Justice Scalia, Justice Thomas, and Justice Alito each wrote a separate dissent. Justice Kennedy, writing for the majority, said, "The Supreme Court long has protected the right to marry as a fundamental right." He cited earlier cases so holding. He explained why we protect the right to marry as a fundamental right. Its importance for the lives of individuals. Its importance for children. Its importance in terms of marriage as a unit for society. And then I think the most important part of the language, he said, same-sex couples are similarly situated as to opposite-sex couples with regard to all of these purposes of marriage. For same-sex couples, marriage plays the same role in their lives. He said that children of same-sex couples should be able to benefit from having married parents. He talked about, in terms of society, marriage for same-sex couples is really the same as opposite-sex couples. He then went on and said that laws that prohibit same-sex marriage also deny equal protection to gays and lesbians. A gay couple can't marry, but an opposite couple can. And he says that's discrimination based on sexual orientation. As I said, each of the 4 dissenting justices wrote vehement dissent. All of the dissents argued the same thing. All said that this should be left to the political process, that it was undue judicial activism. Each state should be able to decide for itself. Now, I introduced the case by saying no one was surprised by the result. Not liberals, not conservatives. 2 years earlier, in 2013, in a case called the United States versus Windsor, the Supreme Court ruled 5-4 that a key provision of the Defense of Marriage Act was unconstitutional. The Defense of Marriage Act is a federal statute. In Section 3 of it said that for purposes of federal law and federal benefits, marriage had to be a man and a woman. And the Supreme Court, in an opinion by Justice Kennedy, declared this unconstitutional. The court said, no legitimate purpose is served by keeping gay and lesbian couples from being able to marry. In light of that decision, I think it was predictable what the court would do here. And I think that really is what underlies this decision. The court sensed that there's no legitimate reason to keep gays and lesbians from being able to express love and commitment, to get all the legal benefits from marriage. Now, my guess is that the primary argument that the states wanted to make is that states should be able to make a moral judgment that homosexual conduct is wrong. But in 2003, in a case called Lawrence versus Texas, the Supreme Court said states can't make that moral judgment. It's based on animus against gays and lesbians. So what the states tried to argue to the Supreme Court is history and tradition. That historically, traditionally, marriage has always been between a man and a woman. But Justice Kennedy pointed out that a history of discrimination is never enough by itself to justify continued discrimination. There has to be another reason. So the primary reason the states gave in their briefs in the argument is that marriage is primarily about procreation. And they said that only opposite couples can procreate without artificial assistance. But Justice Kennedy said that this is both wrong and irrelevant. It's wrong because no state has ever limited the right to marry to couples that have the ability or the desire to procreate. And more important, it's irrelevant because same-sex couples will procreate whether or not they can marry. They'll procreate by adoption, artificial insemination, surrogacy. Justice Kennedy said there's hundreds of thousands of children in the country who have same-sex couples as parents. Shouldn't those children be able to benefit from having married parents? And what that provides for family stability, just like children of opposite couples have always been able to benefit. I think what's important about this case is it resolves the legal issue. In all 50 states, District of Columbia, and all territories of the United States, same-sex couples now have the ability to marry. The second case that I was instructed to talk about, is listed in the handout, is Obamacare health care subsidies. The case is King versus Burwell. The goal of the Patient Protection Affordable Care Act is to make sure that almost all Americans have health insurance and access to health care. Congress found in adopting the law that there were 50 million Americans without health insurance or meaningful access to the health care system. For the poorest among us, the Affordable Care Act says that every state had to include within its Medicaid program those within 133% of the federal poverty level. The federal government was to pay 100% of the cost until 2019 and 90% thereafter. For those just above this income level, but still of lower and lower middle income, health insurance made affordable through tax credits. And the law says that those who qualify economically will get tax credits if they purchase insurance from, quote, a state-established exchange. The law calls on every state to create a healthcare exchange. But Congress constitutionally cannot compel states to adopt laws or enact regulations. The Supreme Court said that would violate the 10th Amendment to the Constitution. So the law says if a state doesn't create a healthcare exchange, the federal government will create, quote, such exchange. At this point, you've only got 16 states that have created healthcare exchanges. In the other 34 states, the federal government has created the healthcare exchange. The challengers came to the court and argued that only those who purchase insurance from a state-established exchange should get the tax credit. Those who purchase insurance in the 34 states where it's a federally created exchange should not be able to get a tax credit. The effect of that, had the court accepted the argument, would be to collapse the healthcare exchanges in the 34 states created by the federal government and maybe collapse all of the healthcare exchanges in the United States. If those who are purchasing insurance through tax credits no longer can afford to do so once the tax credits are removed, that will shrink the risk pool of who's insured. That will drive up costs. The RAND Corporation estimated if the challengers won, the cost of health insurance would go up by 47% on the exchanges created by the federal government. That then would price other people out of the market, further shrinking the risk pool and collapsing the exchanges. It's feared that all the exchanges are sufficiently interdependent, collapsing 34 of them would end all of them. Estimates vary, but it's between 6.5 and 10 million people in the United States who are able to afford insurance through these tax credits and purchasing insurance on the federally created exchanges. The Supreme Court, in a 6-3 decision, ruled in favor of the federal government and said that those who purchase insurance from federally created exchanges or state-created exchanges should be able to get the tax credits. Chief Justice Roberts wrote for the court, joined by Justices Kennedy, Ginsburg, Breyer, Sotomayor, and Kagan. Justice Scalia wrote dissent, joined by Justices Thomas and Alito. Chief Justice Roberts said, the statutory language is ambiguous here. Yes, it says you get a tax credit if you purchase from a state-established exchange, but it also says that there's tax credits if such exchange, and that includes those created by the federal government. He said, ultimately, we should interpret a statute to effectuate the purpose of Congress. He said Congress's goal was to make sure that all who qualified economically could get tax credits. He said, surely it wasn't Congress' objective to allow states not creating exchanges to collapse all of the exchanges. Justice Scalia wrote in angry dissent. I can say that a lot this year. Justice Scalia said, the statute says state-established exchange. It doesn't say state or federally established exchange. He says we should no longer call this Obamacare. He says we should just call it SCOTUS care. I always encourage my students to think of cases not just in terms of legal doctrines, but in terms of their effect on people's lives. The effect of this case is that between 6.5 and 10 million people will continue to have health insurance that otherwise they would not continue to be able to afford. Think of that in terms of the lives saved, the suffering prevented. The third case that was listed in the ad says voting redistricting. And this is an important case for those of us in California. It's called Arizona State Legislature versus Arizona Districting Commission, decided on Monday, June 29th. Partisan gerrymandering is nothing new. It's existed since the earliest days of American history. Partisan gerrymandering is the political party that controls the legislature, draws election districts to maximize, say, seats for that party. It's when the Democratic legislature here in California would draw election districts to maximize seats for Democrats. It's where the Republican-controlled legislature in Texas drew election districts to maximize seats for Republicans. Arizona voters passed an initiative to create an independent commission to draw election districts, to take this out of the hands of the partisan legislature. If that sounds familiar to you, it's because California voters passed a similar initiative to create an independent districting commission. In California, like in Arizona, the districting commission draws election districts for congressional seats, for the United States House of Representatives, and also for state legislative seats. There's about 20 states in the country that have some form of independent districting commission. Members of the Arizona state legislature were upset that they had lost this power to draw election districts, so they brought a constitutional challenge to having an independent commission draw districts for the House of Representatives. They pointed to a provision in Article 1 of the Constitution that says the legislature of each state shall set the time, place, and manner of elections. And they said under this, it has to be the legislature that draws election districts. It can't be a commission. The Supreme Court, in a 5-4 decision, rejected the challenge and upheld the constitutionality of independent district commissions. Here, Justice Ginsburg wrote for the court, joined by Justices Kennedy, Breyer, Sotomayor, and Kagan. Chief Justice Roberts, Justice Scalia wrote dissents, joined by Justice Thomas and Alito. Justice Ginsburg said, this turns on, what does the word legislature mean? So she went through a lot of dictionaries, including ones from 1787, and said, the legislature is the body that holds the legislative power of the state. That almost seems like a tautology. And she says, under the Arizona Constitution, Arizona voters can adopt laws through the initiative process. They hold the legislative power when it comes to passing initiatives. They use their legislative power to create an independent commission, and that's constitutional. At the end of her opinion, Justice Ginsburg said, there's real evils to partisan gerrymandering. We all learned in civics that voters are supposed to choose their elected officials. She said partisan gerrymandering lets elected officials choose their voters. She says this is the kind of good government plan that states should be able to adopt. I was very pleased to see the result in this case. I strongly favor independent districting commissions. In fact, from 1997 to 1999, I chaired an elected commission in Los Angeles to rewrite the city charter. And one of the things we did was create an independent districting commission to draw city council lines, taking it away from those in power being able to draw districts to keep themselves in power. The fourth area listed in the ad is employment discrimination. In the case here that I would talk about is Equal Employment Opportunity Commission versus Abercrombie and Fitch. I think it's a case that was widely misreported by the press. Samantha Eloff went to apply for a job at Abercrombie and Fitch doing sales. She's a Muslim woman. She was wearing a headscarf. The person who interviewed at Abercrombie and Fitch ranked her as qualified, but the person who did the interview had a concern. At this time, Abercrombie and Fitch had a policy that would only hire people to do sales who met, and I'm quoting, the look, capital T, capital L. And the interviewer didn't know she could hire somebody who was wearing a headscarf. So ultimately, the interviewer calls the regional manager and says, can I hire this woman even though she's wearing a headscarf? And the regional manager said, no, of course not. Somebody having something on her head isn't consistent with the look. Well, the Equal Employment Opportunity Commission, a federal agency, brings a lawsuit against Abercrombie and Fitch. Title VII of the 1964 Act prohibits employment discrimination based on race, sex, or religion. And it requires that employers make reasonable accommodation for employees' religion. The Federal Court of Appeals in Denver ruled in favor of Abercrombie and Fitch. The Federal Court of Appeals said, well, Samantha Eloff never told the interviewer that she needed to wear the headscarf because of her religious beliefs. The Federal Court of Appeals said, how do we know that Abercrombie and Fitch had knowledge that this was because of her religion? The Supreme Court, in an 8-1 decision, reversed. I think it was quite predictable. After all, Samantha Eloff didn't say this because she didn't know she had to say it. No one had ever told her that she might not get the job if she wears her headscarf. Justice Scalia wrote the opinion for the court. Only Justice Thomas dissented. Justice Scalia says, there are federal civil rights statutes that for an element of liability requires proof of knowledge. He said, that's not Title VII. He says, Title VII creates liability if it can be shown that a substantial motivating factor in not hiring is refusal to accommodate religion. He says, there's no doubt from the facts of this case that a substantial motivating factor in not hiring Samantha Eloff was that she wanted to wear a headscarf for religious reasons. Now, notice the Supreme Court did not decide that Samantha Eloff had the right to wear the headscarf. When employers have to accommodate the religious dress of employees, is the issue unresolved in this case. What the court says is, here is the framework of analysis. The question is, was it a substantial motivating factor to want to accommodate religion? At the risk of being insensitive, let me pick an extreme example. Imagine that Disneyland is looking to hire somebody to be Snow White. And imagine a woman applies wearing a burqa, so that virtually all of her body, including her face, are covered. Does Snow White still have to hire that woman? Well, from that example, you can reason to less extreme illustrations. But ultimately, the question of when does an employer have to accommodate an employee's desire for religious dress is the one that's not resolved by this case. The final case that's listed in this handout is death penalty lethal injections. And the case is Glossop versus Gross, and it came down on Monday, June 29th. When states adopted lethal injection as the form of carrying out capital punishment, they developed a 3-drug protocol. The first drug was to put the person into deep unconsciousness so the person wouldn't feel pain when the second 2 drugs, and especially the third, ended the person's life. There's no dispute that the third drug, which stops the person's heart, would cause intense pain, excruciating burning if the person was still alive. The first drug that was used in the protocol is no longer available in the United States. The manufacturer doesn't want it used in the death penalty. It is used for medical purpose in the European Union, but they will not export it to the United States. Another drug was substituted. The manufacturer doesn't want it used in the death penalty. It's no longer available. So a third drug was substituted, a drug called Midazolam, and it is not a barbiturate, it's a sedative, and it is not approved by the FDA for use in anesthesia. The concern is that it doesn't put a person into deep unconsciousness. In fact, I'm sure you read instances of so-called botched executions using this as the first drug. There was an instance in January where a person who was being executed in Oklahoma complained of feeling an intense burning sensation when he's supposed to be in deep unconsciousness. The question is the use of this drug cruel and unusual punishment? Does it risk unreasonable pain and suffering? The Supreme Court, in a 5-4 decision, rejected the constitutional challenge. Justice Alito wrote for the court, joined by Chief Justice Roberts, Justice Scalia, Justice Kennedy, and Justice Thomas, and your dissenting opinions by Justice Breyer and Sotomayor, joined by Justice Ginsburg and Kagan. Justice Alito, writing for the court, said, he's looked at the evidence. He doesn't believe that this drug risks serious pain and suffering. And he said, besides that, opponents of the death penalty have been launching, I'll use his words, a guerrilla war against it. They've caused these other drugs that previously used to no longer be on the market. He says, now this person shouldn't be able to come and complain that this drug might cause pain and suffering. And what's probably the most important part of the opinion, he said, The burden is on the person facing execution to show that there is another, more humane alternative. Justice Sotomayor responded to this in a very angry dissent. She went through the evidence and said, this drug has caused great pain and suffering when used in executions, and it risks enormous pain and suffering. And then she says it's unprecedented to say that the person facing execution has the burden of proving another more humane alternative. Says that's the responsibility of the government. Justice Breyer wrote a dissent, joined by Justice Ginsburg, in which he says it's time for the Supreme Court to consider whether the death penalty is inherently cruel and unusual punishment. He said there's such a risk that innocent people are convicted and put to death. He said that the death penalty is so arbitrary in its application. So there's no evidence that the death penalty deters or serves a useful function. Justice Scalia and Thomas wrote opinions responding to that. Justice Scalia is particularly angry. He refers to Justice Breyer's opinion, and I'm quoting, as nonsense, as, quote, gobbledygook. He concludes by saying Justice Breyer wants to repeal not just the death penalty, but the Enlightenment. Justice Thomas, in his dissenting opinion, in his concurring opinion, gives many instances of gruesome rapes and murders and says, this is why we need the death penalty. So I think on the current court, there are 5 justices to keep the death penalty, 5 justices of great deference to the states as the method of execution, but I believe there's probably 4 justices who want to overrule the death penalty, so I don't think this issue is at all resolved for all time. So those are the 5 areas I was asked to talk about, and I'm glad to take 15 minutes of questions. I think I'll simply, well, go ahead. I'll repeat the question, please, first row.
I could probably talk to you all day long about what I don't agree with what's going on. But let's
How about let's just take a minute so other people can ask questions too? And make it a question.
Okay.
Let's make it a question.
Medicare has nothing to do, Obamacare has nothing to do with medicine, it has to do with the tax. And Obama could care less if you have health care or not, he wants to tax you. And that's what he's doing. He's not, because the thing is really, major medical, what he's selling, he's not going to help anybody.
I'm not sure the question there.
Somewhere.
Let me be clear. The issue in the case decided on June 25th, King versus Burwell, was just about whether those who are of lower income should get tax credits from the federal government if they purchase insurance from the federally created exchange. You're right, we could debate for a long time over whether Obamacare is desirable, over whether or not it's constitutional. In this instance, the question before the Supreme Court was a narrow one. Please, just go down here, second row.
Could you comment on John Paul Stevens' new book, 6 Amendments?
It's a very short question. Can I comment on John Paul Stevens' new book, 6 Amendments? It's actually a couple of years old now. It's a short, elegant book. Of course, as you know, John Paul Stevens served on the Supreme Court from 1975 to 2010 for 35 years. He's proposed a number of constitutional amendments. One, for example, is to overturn Citizens United. Another that he proposes is to eliminate sovereign immunity, which protects state governments from being sued. I agree with some of his proposals and disagree with others. The only problem is it's so difficult to amend the Constitution. There have only been 17 amendments of the Constitution since 1791. It takes 2/3 of both houses of Congress and 3/4 of the states. We're not going to get 2/3 of Congress to pass amendments to overturn Citizens United. We're not going to get 3/4 of the states to eliminate sovereign immunity for state governments. So I think it's a book worth reading. I think everything John Paul Stevens says is worth reading. But I don't think we're likely to amend the Constitution in this way. I think Citizens United will be regarded as one of the worst Supreme Court decisions in history. But I don't think we're going to be able to overturn it by amendment. So I disagree with groups like Common Cause or People for the American Way that want a constitutional amendment. I think we should look for ways to reform the election system, knowing that Citizens United can't be overruled. The row over here.
Could you please comment on the recent opinion, Michigan versus the EPA, and whether you think there are any implications that can be drawn from that?
Sure. The case is Michigan versus EPA. It was decided on Monday, June 29th, and it involves a challenge to EPA regulations that sought to decrease the amount of greenhouse gas emissions from coal-fired plants. And the Supreme Court, a 5-4 decision, said that the EPA must, as part of its decision-making, consider the cost of implementing the controls, not just the benefits in terms of the environment. Justice Scalia wrote, joined by Roberts, Kennedy, Thomas, and Alito. Justice Kagan wrote the dissent, and she said, the EPA already considers costs. I think that the practical effect of this decision is going to be minimal. And the reason I say that is all the Supreme Court did was say, EPA, go back and consider costs. But Justice Scalia's majority opinion said, great deference must be given to the EPA as it weighs benefits and costs. So it imposes an additional procedural stage. I don't think that's going to keep the EPA from being able to do this. Please.
Sometimes the court's inaction is really important. Could you comment on a case that the court chose not to hear that you think is really important?
Sure, that's easy for me. I had 4 cert petitions denied at the end of the term. And so I'll talk about one of them where I represented 2 men, the last names are Truvia and Bright, who spent 23 years in prison for murders that they did not commit. The Louisiana courts ultimately found that there was no credible evidence to justify their incarceration. They sued the then district attorney of New Orleans, Harry Connick, and pointed to a long pattern of New Orleans Parish District Attorney's Office not turning over exculpatory evidence to defendants as is required by the Constitution. And the Supreme Court denied a review in the case. I think that wrongful convictions, especially because of prosecutorial misconduct, is a serious problem. Unless you think that this is just my view, none other than the former Chief Judge of the Ninth Circuit, Alex Kaczynski, a conservative appointed by President Reagan to the Ninth Circuit, said that the problem of prosecutors unconstitutionally withholding evidence is widespread. He even said it's endemic, and it leads to the conviction of innocent people. And I think this is an issue the Supreme Court needs to deal with. I'm sorry they denied review in my case. Other questions?
You talk about the role of religious freedom going forward, given some of the cases that were decided.
I think there's 2 that affect our religious freedom. One, of course, is marriage equality. Justice Alito in his dissent, and Chief Justice Roberts in his dissent in Obergefell versus Hodges, the marriage case, so they thought there would now be challenges where people who didn't want to be part of same-sex marriages would object to do so on religious grounds. I think we will see some litigation over that. I'm surprised at this very much. Why? Well, you might have some instances where clerks who work for the government don't want to issue marriage licenses to same-sex couples based on their religion. I think in most instances the government will just have some other clerk issue the marriage license. We wouldn't allow a clerk who had a religious objection to interracial marriage not issue a marriage license. I don't think we're going to allow a clerk to not be able to do so based on his or her religion. I don't think you're going to see lawsuits against clergy members who don't want to perform same-sex marriages. Clergy members have always been able to decide who they want to marry or not marry. When I lived in Los Angeles for many years, I was a member of a synagogue where the rabbi was willing to perform same-sex marriages long before they were legal, but she still will not perform interfaith marriages. That's her prerogative as a clergy member. So the real possibility of lawsuits is, what if there's a business that doesn't want to provide services for a same-sex wedding based on the religious beliefs of the owner? There's a case in New Mexico where a photographer didn't want to take pictures of a same-sex wedding. Or imagine that there's a baker who doesn't want to make a cake for a same-sex wedding. I don't think we're going to see a lot of these cases because the Supreme Court's decision allowing same-sex marriage is a tremendously pro-business decision. It allows all of the businesses that serve the marriage industry to have more consumers. Also, The only way this lawsuit could arise is in a state that prohibits religious discrimination by state law and also prohibits sexual orientation discrimination. I think we will see some cases. I don't think we'll see a lot of cases about this. Now, the other place where religion might come up is with regard to the Affordable Care Act. A year ago, in a case called Burwell versus Hobby Lobby, the Supreme Court said that employers do not have to provide health insurance coverage for contraceptives if it violates the employer's religious beliefs. And there's still a lot of litigation surrounding what that's going to mean, and I think that'll probably come back to the Supreme Court. Please.
Okay, bringing home to California, Prop 14 open primary, what are your thoughts on that from a constitutional perspective, and also what do you think how it relates from a Jeremy and German standpoint?
It's an interesting question. I mean, the problem with open primaries, the Supreme Court has said, is that it allows members who are not a political party to make choices for that political party. So imagine that there's, hypothetically, a very contested Republican primary for president and not a very contested Democratic primary for president. Just hypothetically. Could the Democrats then go and vote for the Republican who's most easy to defeat in the general election, or take that to office at any level? To me, then, as the Supreme Court has said, the problem with the open primary is it allows those who are not a member of the party to be able to make the choices for that party. So it's a concern to me from a freedom of association basis. In terms of the relationship between the open primary and districting, I'm not sure there really is one. At least not one that I can think of immediately. Please.
Professor, if you look back on the last term or two, could you point out a case that you thought was surprising or mistaken?
Yeah, I'll point to a case, and excuse me, mistake, but let me also, so it's not ideological, point to a case where I agree much more with the conservatives than the liberals. Let me use this as an example, a case called Walker versus Texas Division of Sons of Confederate Veterans. Came down on Thursday, June 18th. Texas, like all states, requires that cars have license plates. There's two kinds of license plates in Texas. There's general plates and specialized plates. The general plate is the one you get in the mail if you don't ask for anything else. There's many ways in which Texas produces specialized plates. It allows a nonprofit group to request that Texas produce license plates with sayings or insignias. And so Texas produced license plates that say, quote, "I'd rather be golfing." Texas produced license plates that say, "Go Gators," referring to the University of Florida Gators. The Texas Division of the Sons of Confederate Veterans asked the Texas Department of Motor Vehicles to produce license plates with the Confederate flag. Texas refused to do so. The Texas Division of Sons of Confederate Veterans sued and won in the Federal Court of Appeals. But the Supreme Court, in a 5-4 decision, ruled in favor of Texas. Justice Breyer wrote for the court. He said, when the government itself is the speaker, it can't be argued that its speech violates the First Amendment. He says the government has to be able to speak. It should be able to encourage people to recycle, encourage parents to vaccinate their children. He said license plates are the government speaking. They're like a government-issued ID. They're perceived as communicating a message from the government. Well, since license plates are government speech, and since the First Amendment can't be used to challenge government speech, it's fine for Texas to deny the Confederate flag. Justice Alito writes the dissent, joined by Chief Justice Roberts and also Justices Kennedy and Scalia. Justice Alito says, people don't perceive what's on a vanity plate as a message from the government. If someone sees "I'd rather be golfing," they don't really believe that Texas is encouraging people not to go to work. When they see "Go Gators" on a license plate in Texas, they don't think that Texas is encouraging people to root for the University of Florida rather than the Texas Longhorns. He said what Texas has done here is create a forum for private speech. Doesn't have to, but it has. And when it does, it shouldn't be able to discriminate on ideas based on viewpoint. I like the result in this case. I like that there will not be Confederate flags on license plates issued by the state of Texas. But I'm very troubled by what the majority's decision means in this government speech doctrine. North Carolina has issued license plates that say, essentially, that abortion is murder. They now have the right to be able to do that. In fact, if North Carolina wants to issue license plates that say vote Republican, or California wants to issue license plates that say vote Democratic, they can do so. Now, you have the right to cover that up on your license plate, but they have the right to issue such plates. Or what if a public library now says, we'll only buy books by conservative Republican authors? We'll only buy books by liberal Democratic authors. Can't say that violates the First Amendment. The Supreme Court has even said that the government can speak by adopting private speech as its own. So a city seemingly could say, we adopt all pro-war demonstrations as government speech and prohibit all other demonstrations. That just clearly violate the First Amendment. And yet the reason in the majority would say, you can't bring a First Amendment challenge. So there is an example where I disagree with the liberal majority and agree much more with the conservative dissenters. Last question, I know we're out of time.
You mentioned that in recent decades, the number of Supreme Court cases has decreased. Can you postulate why you think that is, and if there's anything that could ever happen which would reverse that trend?
It's interesting. I early this morning was having a conversation with Joan Piscubic, who covers the Supreme Court for Reuters. And by the way, she has a terrific new book that came out last year called Breaking In, a biography of Sonia Sotomayor. And we were talking about just this question. Her theory is strategic voting by justices. Justices are reluctant to grant review unless they think they got the fifth vote. My pet theory is something called the cert pool. In order to get Supreme Court review, a lawyer files a petition for a writ of certiorari. It takes 4 votes to the court to hear it. It used to be that each of the 9 justices would have his or her law clerks read all of the cert petitions. The practice has developed over the last couple of decades where there's now a pool. 8 of the justices, all but Justice Alito, participate in the pool. 1 clerk will read a cert petition, write a memo to 8 justices. Justice Alito has his clerks read all the cert petitions and write a memo to him. So it used to be that 9 clerks would read the cert petition, any one of which could recommend granting. Now just 2 clerks recommend read a cert petition. My colleagues who are much more statistically oriented than I am could show you why mathematically that should lead to the conclusion less will be recommended and less will be granted. I won't assert causation, but I can show you a correlation. As the use of the cert pool increased by the justices, the grants by the Supreme Court decreased. Just as an anecdote about this, when Chief Justice Roberts went before the Senate Judiciary Committee in the summer of 2005 for his confirmation hearings, he was asked how the docket had gotten smaller. In the last year that William Rehnquist was Chief Justice, October term 2004, the court decided just 85 cases after briefing and oral argument. And Chief Justice Roberts said he lamented this. He said the court should decide at least 100 cases a year. He became chief and the docket promptly got smaller. The court has not gotten to 85 or even 80 cases in any year since Chief Justice Roberts has been on the bench. So this year it was just 66 cases. Now, depending on your perspective, you might think it's good or bad that the Supreme Court is doing less, but it does mean that more major legal issues go a longer time before being resolved. Thank you for coming and thank you for having me.
I don't know how your memory is, but all those exact dates, let alone what the meaning of the law was. Thank you, Dean Chemerinsky. We really appreciate you being here. With that, I'd like to bring up the President of the Chamber once again to update us on what's coming up with the Chamber of Commerce. Thanks for coming.
Great, thank you. And thank you, Dean. You know, if my classes were that interesting when I was at law school myself, I probably would have shown up for more of the Friday afternoon common law classes. In any event, we have some great events coming up that I just want to inform you about. So our next chamber event is our Chamber Mixer. It's on August 27th. It's going to be at Cucina Enoteca over here in Fashion Island. Should be a lot of fun. The food's great over there, and they have excellent drinks. Next month, our speaker here at Wake Up Newport is on September 3rd, and that's our new supervisor, Michelle Steele. Her representative, Tim, is here this morning. Thank you for coming, Tim. Good question as well. On September 17th, we're going to do our, I think it's our 18th or 19th Fire and Lifeguard Appreciation Dinner. We're moving it this year over to the Marriott Hotel, so it's going to be a little bit different before you've been to the dunes, and we have it on the beach. Well, we're going to kind of upscale it a little bit, so probably no flip-flops this year, but it's going to be a great event, and that is open to the public. If you want to get more information about that, we got flyers in the back on all these events, as well as you can go to our website at newportbeach.com. On September 19th, we're going to be doing a Green on the Green Expo, Eco Expo, over at the City Hall Civic Green. We've got a lot of great things going on there. We're going to have, let me just run down quickly the list. We're going to do a document shredding event, so if you have documents at home that you need to have destroyed, you can bring them down there, they'll do it for free. We'll have e-waste drop-offs, so if you have computers or old cell phones or printers or things like that, TVs, they'll take it all for you, and they'll recycle it, so you know it's going to a good place. We're going to have a whole selection of electric, the new model, electric and hybrid automobiles from, I think Tesla's going to be there, I know, BMW, Fiat, Chevrolet, and probably 7 or 8 different manufacturers. So that'll be interesting. We've got a lot of environmental groups that'll be there with information. We have businesses there that are eco-friendly, and if you have a business that's eco-friendly you want to join, there's applications in the back, and you can also sign up online or call me and we can discuss it. And then the last event that I'll mention to you is one that I'm kind of excited about. It's October 23rd. Every year the Chamber does an economic forecast event. We've had some pretty good speakers in the past, but this year I'm proud to announce that we have a new relationship that we established with the U.C.I. Anderson School of Business. And so we're going to have 2 of the Anderson Forecast speakers. The Anderson Forecast is a very prestigious forecast from the Anderson School of Business. It's well regarded by businesses and governmental organizations throughout the state as well as throughout the country. And so this is part of the newest relationship that the Chamber's established with the UCLA Anderson School to bring you some quality programming. So we're going to have 2 of those speakers there. They're going to the new forecast, I believe, comes out in September, so it'll be pretty fresh, and they'll talk about what we can expect in 2016 on the state and federal level, as well as more of a county level. And then our third speaker I'm also excited about is Ed Fuller. He's the he's the president of the Orange County Visitors Association. So they're like the visitor bureau for the county. He's going to talk about tourism and what it means to Newport Beach and the county in the coming year. If you haven't noticed, the tourism business is booming lately. All the hotels are full. Lots of people are visiting Disneyland and all those other places. So that should be a very interesting topic to cover. Maybe we get PHG to be a sponsor since you own so many hotels. Corey. In any event, that's all I have for you. If you are not a member of the Chamber of Commerce, I don't know why you're not, please see Jim Villers in the back. He can hook you up with that. If you have any questions, I'll be around afterwards. Thank you all for coming. Hopefully we'll see you at something soon.